All right, with that, we will move on to our second presentation this evening. Item E2, short-term rentals. A report by planning staff regarding draft changes to the zoning code creating new standards for short-term rentals and results of October information meetings with stakeholders. Short-term rentals are regulated as bed and breakfast home and bed and breakfast inn in the current zoning code.
Mr. Chair, this is Bill Fyander. I am not Dan Warner.
Welcome back.
Yeah, many times we do interchange personalities here, but so tonight I'm Dan Warner. I'm going to introduce Mr. Hall, who is shown as me. So don't worry, we're all good. But that's the best way to get you audio from us tonight. So I just wanted to give a little background into the short-term rental history, how we got here, and then Mike can take it away with the proposed amendment and the process that we're going through. You know, but short-term rentals such as Airbnb have really been on our radar for a few years, but when we do our code amendments, but we just haven't had it rise to the top. We haven't had any complaints over the years, and that was until recently. So we've always known it was something we probably need to update in our code. Within the last 12 months, we did start receiving a complaint in the Auburndale neighborhood with some of the short-term rentals. That went through an enforcement process, which ultimately ended in a Board of Zoning Appeals hearing, which found that, yes, indeed, short-term rentals do qualify as a bed and breakfast home, and that is what our current definitions in the zoning code allow. So a bed and breakfast home was determined to be the equivalent for short-term rentals. It was my decision at that point in consultation with legal that it might be a good idea to pause enforcement until we can truly have a properly researched and vetted code amendment for short-term rentals. Even though the Board of Zoning Appeals made that determination, it was pretty clear to us that it was not a very good hand in glove fit. There were certain distinctions that just did not make sense. And so before we went forth on any enforcement, we pulled that back and has done some research and have come forth back with a proposal on short-term rentals. We did present that to owners and operators of short-term rentals in the last week. And so Mr. Hall is going to present, well, in addition, we did adjacent neighbors as well. We sent out almost 500 notices. So we had quite a bit of coverage on this. There was 2 very good sessions that we had presenting this proposal to those affected, those stakeholders. So tonight, I think Mr. Hall will just go over those questions that came out of those sessions, as well as share with you the research and the proposal as presented to those stakeholders last week. And then my guess is, since you have not seen this, commissioners, my intent would be to send this presentation back out to you all after tonight. So with that in mind, are there any questions about background before we hand off? Okay, if not, Mr. Hall, take it away.
Thank you. If you could go to the next slide, Chris. Okay, this shows you where we're at in the process. We've done the research. We had 2 stakeholder meetings last week, And tonight we're having the discussion. This is not a public hearing. It's for discussion. Then we'll come back potentially as early as December 21st with a public hearing. It's hard to say, but we'll be back shortly, I expect, with a recommendation and for a public hearing, and then it'll go to City Council. Next, please. Okay, so a bit about the research. So in your packet, along with the cover memo, there's a report that was done by one of our staff, Melissa Fahrenbrook, and also a draft of the code changes that we're proposing. So collected information on March 24th, 2020. So when you do this kind of research and you look on these sites, you have to go months into the future, because if you try to collect it at a point in time that's too soon, the sites will be booked. And so the dates we used were November 6th to the 13th of this year. We searched the Vrbo, Flipkey, HomeAway, and Airbnb platforms. We found a total of 32 properties in city limits, 25 of which are non-owner occupied. And there might be more sites, I'm sure there are, but we found 32 at the time we looked at them in that November window. So they're pretty spread out for the most part. There are two clusters, I would say, clusters in Holiday Park and the cluster in Auburndale. The Auburndale cluster is not it's not a very major cluster. There are really three close together, but that's what initiated the enforcement action back at the beginning of the year. Next slide, please. Okay, so this shows you how they're distributed in the different zoning districts. I think the important thing here is that most of these are in single-family residential zoning districts, with some of them being in multifamily zoning districts. There are only a few that are in commercial and industrial and mixed-use districts. And really the issue here is not so much how these fit in the other districts. These are at their worst, these are going to be like motel or hotel rooms. So the real issue is, are they appropriate in single family districts? We feel that they are, as long as they're controlled properly. Next slide. We looked at other regulations in other cities. I won't spend a lot of time on this. I think the important thing here is that Lawrence they adopted some standards a few years ago, or about 2 years ago, I believe. And they came back recently, revisited those standards, and they decided to prohibit the non-owner occupied short-term rentals in the single-family residential districts. The other thing that's important about what they do is they do an initial inspection, and they require a renewal every 2 years. Keep in mind, Lawrence also requires licensing of all rentals, all long-term rentals, in addition to short-term rentals. Manhattan, they haven't really specifically regulated this. They know that they need to address it. It's an issue over there, as I understand. Overland Park, they don't address short-term rentals any different than long-term rentals. They require licensing for rentals. Just to be clear, Topeka, we do not require licensing for rental of property, residential property. And KCK, they require a special use permit and public hearing and action by the governing body, and they require inspections every 2 years. Next slide, please. Okay, so this doesn't cover all of what's in the draft, but this is what's important. So currently, we define these are defined as bed and breakfast home, which is a owner occupied. Bed and breakfast inn is non-owner occupied. And then we have, but the thing that is important in our current code is there are only two categories, and the bed and breakfast inn allows up to 10 guest rooms. As proposed, what we're proposing is we update these so they're more like what's happening in other cities where they've updated them, and also that they reflect current practices. What's happened a lot in the last 5 to 10 years is not only has the sharing economy grown, but internet commerce has grown as well. And these online platforms have gone into use. And so that's changed things quite a bit. And so we're recommending that there be 3 categories. Type 1 would be the owner occupied with a maximum of 3 sleeping rooms for a period of less than 30 days. Type 2 would be non-owner occupied, maximum 3 sleeping rooms for a period less than 30 days. And type 3 may or may not be owner occupied, 4 to 10 sleeping rooms for a period less than 30 days. So when people think of bed and breakfast inn, if you think the traditional bed and breakfast inn, it's really comparable to the type 3 more than the types 1 and 2. I'd say the types 1 and 2 are probably more common in short-term rentals. The other thing we've done is we've added a definition, or we're proposing to add a definition for owner occupied, where the owner must reside for 182 days or more per year, which that's about half of the year, 365 days in a year. I think the other thing that's important to point out is currently the bed and breakfast home and bed and breakfast inn, the bed and breakfast inn allows up to 4 sleeping rooms or guest rooms, and we're proposing that it be limited to 3. There's not really a magical number, but we've proposing that it be scaled back by 1. Not sure that's the best thing to do, because we do have non-owner occupied short-term rentals out there now, which are bed and breakfast, actually meet the definition of bed and breakfast inn, that have more than 3 or 4 sleeping rooms. They're houses with 5 bedrooms in some cases. I don't know how many there are, but there are some. Next slide, please. Okay, I think what's important, and this is really key, is how this is treated in terms of whether the use is allowed, conditional, or prohibited in residential zoning districts. So if you are familiar with the land use table, the zoning matrix in our code, it lists all the zoning districts and all the different uses. And currently, bed and breakfast home, bed and breakfast inn are listed as uses. And in the table, it'll identify whether that use is allowed, conditional, or prohibited in various districts. Currently, both bed and breakfast home, bed and breakfast inn require a conditional use permit in the single family and 2-family residential districts. What is being recommended is that a conditional use permit not be required, but that they be allowed subject to specific standards. And the reason for that is when you think about how many of these there are, we haven't really received a lot of complaints. We've received complaint because they were concentrated probably more than anything else. And also related to the complaints we received is there's no parking standard. There's no clear parking requirement. So we're recommending that they be allowed in these districts subject to these standards. Next slide, please. So a couple important things here is under the current standards, homes and inns, they must retain their appearance as a single family residence, giving no appearance of a business use. And that's important because a lot of times these just go unnoticed, I believe, because they just look like a regular house. We're recommending that not change. So what's important with bed and breakfast homes is currently they may not be used for weddings, receptions, and similar events. Bed and breakfast inns may be used for these events, but with many restrictions. So what we're recommending is short-term rental types 1 and 2 may not be used for weddings, receptions, and similar events. Remember that there's another category, short-term rental type 3. Next, please. So currently the parking standards are not very clear, or they're just non-existent. It doesn't specifically address it for these uses. There's no stated off-street parking requirement for bed and breakfast homes. There are for events in bed and breakfast inns, but if an inn doesn't have an event, then it's not clear that there's a parking standard or a parking requirement. What's recommended that for short-term rental type 1, remember, short-term rental type 1 is the owner occupied, that 1 off-street parking space be required for the primary resident and 1 off-street parking space for transient guests, 2 spaces total. So what we're recommending is that there be 2 spaces required in most cases, no more than 2 spaces. But what's also important, and I'll show you this in the diagram in the next slide, is that 2 of those spaces may be provided on the street frontage if the residential lot has 44 feet of unobstructed street frontage. So for short-term rental type 2, it's the same as a single-family dwelling, 2 spaces depending on the size of the dwelling. Up to 2 of those spaces may be provided on street with 44 feet of unobstructed frontage. You might ask why there is a difference, and the reason there's a difference is because with a owner-occupied short-term rental, consider that you have the owner who will have their own need for parking. They'll have 1 or 2 vehicles typically, and then they might rent a guest room to each individual. So each guest room that's occupied quite likely will be associated with a car. So someone occupying a single guest room will drive there in most cases. With a non-owner occupied, which is the type 2, typically someone who rents a non-owner occupied short-term rental is renting the whole thing for the whole building, the whole residence for their single use. You're not going to have 3 or 4 unrelated people or people that don't know each other staying in a non-owner occupied short-term rental. Next slide, please. So this is a diagram that illustrates how the parking standard would be applied. So in this case, this is actually an existing short-term rental. It's an owner-occupied short-term rental in Auburndale, and there's potential for 2 off-street parking spaces off the alley. There is some street frontage, but there's only 37 feet of street frontage. So in this case, as under the recommended standards, with on-street parking. Next slide, please. So another issue, as we have discovered, based on the BZA case earlier this year, is that one of the issues is concentration of these within a particular neighborhood. So currently, there's no express requirement. Certainly, if someone applied for a conditional use permit, the issue could arise, parking could arise, and it could be addressed as part of a conditional use permit, but there's no specific standard for it, no restriction. As recommended, for short-term rental type 1, there would be no standard, there would be no restriction, but for the type 2, they could be located no closer than 500 feet from another type, short-term rental type 2 or 3. Next, please. So the other thing that's important to note here is that if one or more of these standards cannot be met, the owner may apply for a conditional use permit. Next. So for the short-term rental type 3, compared to what's currently the bed and breakfast inn standard, is more specific off-street parking standards are recommended, and we've drafted those. Next slide. Thank you. Okay, so we have a number of questions and comments that came out of the stakeholder meetings. I'm just going to go over a few of those. I think these are the ones that require most of our attention. So one of the questions is, why change the requirement from a CUP, conditional use permit, which requires a public hearing, which invites comment and input from neighboring property owners? Why change this to an administrative permit where no public hearing is required? And our answer to that is, I think I mentioned it before, is that a lot of times people aren't even aware of these exist. So requiring a conditional use permit for them is really an unreasonable and unnecessary requirement. I think the other thing is that a conditional use permit, if there are a lot of these, you potentially lead to arbitrary decisions. If they're not bound to certain standards, then they're kind of all over the place. And consider that back earlier this year, when the decision was made to not require a conditional use permit, if we were to apply that requirement in a very even-handed, equitable fashion, we would have required all of those operators to obtain conditional use permits. And when you think about the burden on the Planning Commission agenda and on planning staff, it's just a lot of work. And if we have, it's staff's recommendation or opinion that if we have well thought out, effective standards, then requiring a conditional use permit is unnecessary, and it's not even really a desired outcome or a desired process. So next question is, if a current owner operator does not now meet the concentration separation standard of 500 feet, how will that be resolved going forward? So that's a really good question, but actually we've looked at it, and currently all of them meet that standard that we're aware of. All of them that we're aware of meet that standard. There is a way to address that. You could add a date where that takes effect, that concentration standard takes effect. It could be specifically included in the code, and that might be something that the legal counsel would advise us to do or not to do, but that's one way to address it. Keep in mind that the existing short-term rentals in single-family residential districts, they are not grandfathered, so you can't apply that logic to these because they are currently require a conditional use permit. We're actually recommending that the standards be less rigorous than they are now, if in terms of whether a conditional use permit is required or not. Next slide, please. Next question is, will the administrative permit include a time limit? Will it require the owner operator to renew or reapply? So as recommended, the answer is no. Typically, in the case of a zoning application or a zoning permit, we don't impose time limits. It's not that we can't. Certainly with a conditional use permit, we can impose a time limit. But if you compare this to the home occupation permit, home occupation, the idea with a home occupation, like short-term rentals, is that it can be done almost incidental to a residential use. And the nature of the use, the nature of the building, the property remains residential. So we look at this as being similar to a home occupation. So as recommended, as drafted, we're not recommending there be a time limit. On the other hand, that's something that might be a relevant and necessary requirement. So I think that that's something that, we're asking you to consider that and to advise us if you think there should be a time limit. And if there's a time limit, it could be a 2-year time limit, it could be a 3-year time limit. I think you just establish it in the code, and that's what at least one other city we know about has done. So another question that came up, other cities require operators of short-term rentals to maintain liability insurance. Is the city considering that as a requirement? We're not recommending that at this time. And I think we could research this a bit more. My understanding of the liability insurance is that it's intended to protect the property owner, not the neighbors. So it's really not if that's the case, it's really not a zoning issue. The purpose of zoning isn't necessarily to protect that property owner. It's protect neighbors from impacts of that property. Consider that Airbnb, from what I understand, they require an insurance policy, and that's to protect the owner from a renter that let's say they have a party or something, they damage the home. That's my understanding of the purpose of that liability coverage. So I'm not sure why this is necessary. I think that's something that we could look into. If it's just there to provide a barrier, that's not really what we're trying to do is provide barriers to short-term rentals. One thing that something to consider, and something that really came out of the BZA case, is that in some cases, the fact that owners can use these as short-term rentals provides them an income stream that supports their investment in the property. The other thing is if they're going to attract renters, they have to have a decent property to attract renters. They're not going to attract a short-term rental if their property is not well maintained, generally speaking. And so we don't necessarily want to put up barriers to short-term rentals. I think the intent is to control their downside, their potentially adverse impacts. So that's our presentation on this, and I would love to hear your comments and questions and direction. Thank you.
Mr. Chairman, I have one question for Mike.
Sure.
I'm thinking of somebody who has a conditional use permit right now, and if this is adopted, let's say they come in as a type 2 or would qualify, classified as a type 2, but they can't meet one of the standards. And I think one of your slides indicated earlier that they would have the opportunity to apply for a CUP if they couldn't meet the standard. But if that's correct, my question is, does that mean that somebody currently holding a conditional use permit would have to come in and apply for a new one under that fact situation?
Commissioner Kalb, that's a good question. From what I know, we have not approved any conditional use permits for short-term rentals or for bed and breakfast homes or inns. So that wouldn't apply in that case. Even if we had, and we might have, I'm not aware of any, I couldn't find any, we couldn't find any. But if we had, then they would, I believe, be considered a legal non-conforming use, and they would not have to meet the new standard. So if there was something, if we had approved a conditional use permit, we basically gave them approval to operate under their current or the conditions at the time they applied. New standards being adopted would not affect them.
Yeah, I like what you're doing. I like the concepts that you're looking at. I think it would be an improvement over what we have right now on the books. But I just would ask you to be sensitive to any situations that arise or you identify where somebody's holding a current conditional use permit and would be adversely affected by the new regulations.
Thank you.
Mr. Hall, you talked about potentially a public hearing back before us as early as the December Planning Commission meeting. What's your process between now and getting back before us as far as any additional public hearings or content in that time, or are you just refining the revisions to the document itself?
Mr. Chairman, we've identified all these issues and questions, and I think the important thing, first of all, is to be able to answer those questions. We've prepared we're in the process of preparing a Q&A, frequently asked questions and responses to those, just so that can be part of the record. It can also be put on our website, but also we can do a little more research and put a little more thought to how to maybe refine these standards to address those issues. And then that's what we would bring forward. That'll take some time. And we expect we'll get some more input. We've gotten quite a lot of input, actually, a lot of interest. And there are some concerns of people. Not so much the owners. I think the feedback we've gotten from owners is fairly positive, but neighboring property owners. So at this point, it's just a matter of time putting that together and bringing it back. The other thing that might affect this is what our agenda looks like in December. It looks like we might have a number of items on the agenda. And so, we want to make sure that this gets the attention it deserves. And so that could affect how soon it comes back.
Mr. Chairman, one other question for Mike, if I might. Looking at the proposed text amendments, I note that the 182 days is set out as per calendar year. Is that same thing true of supposed to be true of the 30 days? We're talking about 30 days per calendar year for types 1, 2, and 3, right?
Yes.
Okay.
Let me just add something to that, though, Commissioner. One of the suggestions we received from a current operator is to define short-term rental by 28 days because it's consistent with the way the state of Kansas deals with these in terms of revenue collection. And so that's just a minor change we might make is define it by 28 days rather than 30 days.
Is that what other cities have done?
It varies. It seems like it's 28 days, 30 days, 31 days. I think 28 days is probably because that's the shortest month of the year.
Okay. Thank you.